We're live.
Good evening. This is the House Judiciary Committee. It's 8:30 on the 12th of April, 2021. We have several bills that have finally arrived from the Senate that have been put to us as to decide whether or not to concur or not. The first bill we're going to take up this evening is House Bill 16. This bill, as we sent it over to the Senate, addressed issues regarding immigration and the ability to cooperate with ICE and ICE detention facilities. I'm going to ask Delegate Moon if he could give us a sense of what the amended bill does from the Senate. Delegate Moon, are you still with us?
Yes, can you hear me?
Yes, go ahead.
Great, thank you. So you'll recall the original bill, HB 16, was one to phase out the 3 ICE for-profit county-run detention facilities in Maryland, one of which is now voluntarily shut. So the bill effectively would phase out the remaining 2 for-profit facilities and prohibit future new county for-profit facilities from opening. The Senate took the bill and they added, honestly, the least controversial portions of the Trust Act into the bill. And it's actually a bill that, for those who have been around, the Trust Act deals with the local police entering into agreements with ICE to share information, detain, hold immigrants, and it has to do with that police interaction. But we passed that bill in full several years ago. And so the parts that moved into this bill are very straightforward. They basically restate existing law. So they're just a reminder of existing law that police, unless it's part of a investigation or law enforcement action, should not be randomly asking people for their papers, essentially, and sort of checking people's immigration status or randomly trying to transfer people they suspect of being undocumented to ICE. Again, this is existing law. It's not really creating new policy. It's a reminder, and it's a reminder that's been needed because in Frederick, for example, there have been at least 2 cases where the police were, in fact, bothering people, say, eating lunch, having a sandwich, to ask about their immigration status. And that was deemed a violation by the courts. And so the Frederick has had to pay hundreds of thousands in settlements. So all the Senate added was, again, a clarification that law enforcement should not be checking on the immigration status of people, again, outside of a legitimate law enforcement investigation.
Move to concur.
Second.
There's a motion to concur and a second. We're going to have 5 minutes of debate on this legislation, and then I'm going to call the question. Starting now with Delegate Griffith.
Can you hear me? I feel like my screen is freezing up.
We can hear you. You have no more than 5 minutes of debate on this.
Understood. How does this affect the 287G program?
It unfortunately, in my opinion, doesn't do much damage to the 287G program. If you look at what was the last paragraph of House Bill 16, one of the last paragraphs, it has a clarification, in fact, explicitly that this won't upset the 287G programs in existence in the state.
What about programs not in existence? Like, say, a jurisdiction has an election and that sheriff comes in and wants to establish a 287G program based upon—
Yeah, again, unfortunately, that was attempted in another bill, but that provision didn't make it into this bill.
Thank you.
Delegate Cox.
Thank you, Mr. Chair. So if I could ask Delegate Moon, could you just real quick with a couple of bullet points, what are the changes the Senate made?
So they added pieces of the old Trust Act into the bill that say a law enforcement officer may not ask questions, detain, try to transfer to ICE. Basically, local police are not to do immigration enforcement, immigration checks, or immigration transfers, again, outside of a actual law enforcement purpose, an investigation, or they're subject to a 287G agreement as described. But outside of that, they're not supposed to be just running immigration checks. That's the added language.
So I know you mentioned Frederick, and I want you to know that, as Delegate Pippi mentioned on the floor, Delegate Pippi and myself are the only two legislators, I think, in the entire General Assembly that have toured a 287G facility. And one of the interesting aspects of the facility is, first of all, it's run by Homeland Security. It is actually nicer than the jail that citizens have to spend their time in. And additionally, under the program, they don't ask questions like you mentioned. So it sounds like the current bill, like you just mentioned, so long as they're operating lawfully under a 287G program, if the question of status of immigration, for instance, 3 different individuals in Frederick were provided knowledge from our sheriff and from ICE that they were actually US citizens, and they didn't know that. So in the context of the ICE, or excuse me, of the 287G memorandum of agreement, then I think what you're saying, Delegate, is that any questions that would be lawful in that capacity are still permissible. Is that what I'm hearing?
That's correct. And further, there's a whole nother section, to be fair to what JPR added, dealing with, I believe, the Vienna Convention. There's, it's supposed to be that if you detain a foreign citizen, for example, that they have access to their embassy. So
Right.
there are those types of clarifications. But again, these are all lawful contexts that you're describing. The scenario that the JPR language is intended to address is some of the situations that have led to lawsuits in Maryland, which is where officers have stepped outside of their jurisdiction and bounds to start acting on their own accord to ask about immigration status and things of that nature.
Well, just to clarify the record, I don't believe that any wrongdoing was ever admitted in those settlements, just to clarify. So
Okay.
I know that's the position of the ACLU, but it never went to trial, right? And so until it's proven up in a court of law, I don't think that we should disparage the officers who had an entirely different story to that. But anyway, thank you.
Delegate McComas for 1 minute.
What was the vote in the committee and in the Senate?
The floor vote in the Senate was 30, and it was partisan. I mean, if that's what you're asking, it was partisan in both respects, not perfectly partisan, but all the R's were no's.
And what about in committee? Or you don't know? I'll look it up. Never mind.
All right, that concludes the 5 minutes. I'm going to call the question. On House Bill 16, the motion was to concur and there was a second. All those in favor of concurring, please raise your hands. In favor of concurring on House Bill 16 and the Senate's amendments, delegates Lopez, Davis, Shetty, Bartlett, Fisher, Crutchfield, Conaway, Williams, Jones, Moon, Anderson, Cardin. All those opposed to conforming, I'm sorry, delegates Cham, Malone, McComas, Arakan, Cox. All right, the motion to concur is adopted, and we will take that to the floor. We're now going to go to 5 minutes on House Bill 18. House Bill 18, as it left the House, was a bill that dealt with the right to counsel. It has come back from the Senate different. It is no longer, and is clearly not, a right to counsel. It's struck out in the bill in multiple places where it said right to counsel. And now it says access to counsel. It expands the number of opportunities for people to be able to use that access to counsel. However, having said that, it is different from a right to counsel. So they expanded the universe of people who can get it, but it is not as strong as a right. There's also the language that we offered for notice is in House Bill 18. It is still in House Bill 18, although it requires only one of the forms of communication and not two of three. Dylan, Delegate Grammer is outside in the waiting room, would like to be brought in. We're going to do 5 minutes of debate on this bill, and I'll begin with the Vice Chair.
Thank you, Mr. Chair. And I don't know if anyone has the answer to this question, but did the Senate define what access means? I'll just say for the record, and I certainly don't want to, I'm not going to try to impede or hold up this important piece of legislation because it's needed. But I do think that there is a difference between access and right to counsel. And I think that what the House passed was very clear and would help a lot of Maryland residents. And I think access leaves a lot of ambiguity. So I'll just state that.
It doesn't explicitly say what the definition of access would be. Having said that, I will say that in the end, I will be making a motion in a moment to ask the committee to concur in any case, but we'll hear from more people who maybe can talk about that in greater detail. Delegate Fisher.
Thank you, Mr. Chair. Can you hear me okay?
Better now. Go ahead.
Okay, sorry, Mr. Chair. I just wanted to thank you and the Vice Chair for your leadership on this. I know that this is the legislation that I've sponsored and worked on. I'm not a huge fan as well of it not being clarified as a right. I think the work that we did in the House was good, and there was room for a later time to expand. But I would ask this committee and the greater body to concur due to the timing of this bill and how needed it is in all of our communities. But I will also speak more specifically in my district, as I have a huge rental population and this is needed. So just wanted to say that for the good of the committee. And thank you, Mr. Chair, for all your hard work, the hours, the meetings, just for months and even before we got here on this with me and others. Just wanted to thank you.
Thank you. Delegate Bartlett, please.
To be brief, I'll say ditto, but I'll also say that we passed a bill with a right to hunt, but we don't have a right to counsel.
Delegate Cardin.
I was just going to ask what Delegate Fisher's feelings are on this to know what her recommendation is. That's all. Thanks.
That's all right. Delegate Griffith.
Thank you, Mr. Chair. What does access to counsel even mean in this terms? Is it defined? I'm just trying to understand what the bill even does now.
I think that the goal will be to effectively what the bill will do now is MLSC, Maryland Legal Services Corporation, will coordinate with local housing advocacy groups to help people get counsel if they ask for it. That is the best that I can tell. There is a distinction between that and a person having a right to counsel, which would be distinct. But having said that, access to counsel, you could see it as MLSC facilitating through other organizations a right to counsel.
I'm not trying to eat up all the time, but with all due respect,
Sure.
In this late hour, you mentioned that's what you think it's going to do. I'm just.
No, that's what it does. That's what it does.
Okay.
It basically would, MLSC would facilitate people who are looking for legal assistance and were having problems with an eviction. They would facilitate people getting access to counsel. It is not a right to counsel. A right to counsel would be if they didn't have a lawyer and they were at a hearing and they wanted to go forward, but they didn't have a lawyer, then there could be a postponement or something along those lines. This is distinct from that.
So what now happens? Sorry, I don't mean to cut you off. I know we're short on time. I'm trying to be respectful of your wishes.
That's
so what
right.
happens now that funding was established in another bill that was supposed to go to council? Where does that money go now?
No, the money that would be accumulated, and that's in House Bill and the fee bill in 31. The bill also includes the fund. The bill includes the now called the Access to Counsel Fund that would receive money depending on the passage of the next bill for it would receive money from the summary ejectments, All right, seeing no further comments or questions, I'm going to call the question, and I'm making a motion to concur with the Senate amendments.
Second.
Is there a second?
Second.
There's a second. All in favor of concurring with the Senate amendments on House Bill 18, please raise your hands. Delegates Fisher, Lopez, Shetty, Davis, Bartlett, Conaway, Crutchfield, Atterbury, Anderson, Moon, Jones, Williams, Cardin. All those opposed, please raise your hands. Delegates Cham, Malone, McComas, Erican, Cox. I'm just confirming, is Delegate Grammer in the room, and I'm just not seeing him. Okay, and Delegate Griffith, I see you as well. The concurrence is adopted. That will go to the floor. We're going to go to House Bill 1187 now. House Bill 1187 is I don't think that I could actually be fair to the committee. I could go for a much longer time than 5 minutes to express my absolute and utter anger at 1187 right now. I'm going to make a motion to concur, but what we did was passed a significant piece of juvenile justice legislation in the House, and at the last minute, the Senate of Maryland has sent back an extension of the Juvenile Justice Reform Council, where they decided that the person who runs it should be the person who runs the agency. Those were the substantive changes. They got rid of the substantial changes that were going to be made in reform. Fortunately, there's still $2 million so that ROCA can run programs with the Department of Juvenile Services. And for that reason, I would ask for a motion to, I'm making a motion to concur with the Senate's amendments on 1187 and would ask for a second.
Second.
All right. Brief, Delegate Fisher, do you have more comments or your hand's still up from the last time?
I'm sorry, Mr. Chair, it's old hand.
All right. Thank you very much. This conversation is not over on issues related to juvenile justice. Delegate Anderson, I'm going to limit it to just a couple minutes here because we have to keep moving and they rang the bells.
Yeah, I won't be long. I just want to, so the person that you're saying is going to be running this is Sam Abed or Abed.
And
right?
Secretary Abed is doing good work in the Department of Juvenile Services. The problem is the next work that has to be done is a critical analysis of the programs that DJS continues to run and runs right now. And I think there are a lot of people who feel, with no disrespect to the secretary, that it would be better to have another person outside the department leading that effort as opposed to the person who's leading the department.
Okay. And this
That's why, with absolutely no disrespect to Secretary Abed.
I got it. This question is not really related to that, but in light of the last bill we just talked about, we had a bill where juveniles could be interrogated with by the police officers, and we're going to give them the right to counsel. Did we ultimately do that?
We passed that legislation. It's sitting in the Senate.
All right. Thank you, Mr. Chair. That's all I got.
Thank you very much. I'm going to call the question on 1187. All in favor of concurring with the Senate amendments in 1187, please raise your hands. Delegates Anderson, Lopez, Malone, Shetty, Davis, Bartlett, Conaway, Atterbury, Fisher, Moon, Jones, Williams, Erican, and Cardin. All those opposed to concurring, and Griffith. All those opposed to the Senate concurring with the Senate amendments. Delegate Crutchfield. Thank you very much. We'll concur with the Senate amendments. House Bill 31. We're going to go for 5 minutes here. House Bill 31 is significant. I'm not sure if it's significantly different than the way it left here, but it is different in a couple ways. House Bill 31, there's a clause in 31 that connects it to House Bill 18. It lowers the amount of the increase from $8 to from 68, which was in my original bill, to $50. And it takes the $50 that is raised in summary ejectment cases, puts $33 into the Access to Counsel Special Fund and $17 into the Maryland Legal Services Fund. It still contains the increase in filing fees for civil and criminal cases that were in the bill originally. It sunsets in 2 years. The additional $50 sunsets in 2 years. It does not allow for a pass-through of those fees to the tenant, but again, it sunsets in 2 years. And that is what JPR did to the fee bill. Delegate Williams. You're muted. There you go.
I'm sorry, I had to unmute. You answered part of my question, Mr. Chair. I think part of the reason we were kind of dealing with this piece of legislation was really because of the deficit that Maryland Legal Services was suffering because of so much of the additional services that they have been providing to indigent and low-income residents here in the state of Maryland. And so I guess my question is, will this lower amount that has now been proposed by the Senate will deal with the deficit that this not-for-profit legal organization is providing to low-income and indigent residents here in the state of Maryland?
I'm sorry, I was distracted. I hate to ask you to repeat the question, but would you repeat the end of your question, please?
I just was wondering if the dollar amount that was proposed would be deals with the funding shortage that the Maryland Legal Services Corporation was facing. It's my understanding that part of the reason why we were doing this is, one, to pay for the right to counsel, which is no longer a right to counsel, which is really not even defined by the Supreme Court. Right to counsel is a very defined term under Gideon versus Wright, but I'm gonna not digress down that road right now. But the other reason that we were doing this bill was to deal with the budgetary shortages that the Maryland Legal Services Corporation was facing because of the enormous just need that they were just servicing during this pandemic as it relates to indigent and low-income individuals here in the state of Maryland. And so my question is whether or not this lower amount that has been proposed by the Senate is sufficient to deal with that financial stopgap that this important not-for-profit organization here in our state.
It should be, and the reason for that is that there was $6 million moved from the Lost Property Fund that was moved into MLSC. This bill would, through the increase in the filing fees for district court and circuit court, those two fees would fill the remainder or the better part of the remainder of the gap, probably leaving about give or take $600,000 off the side. And then the additional money that comes from the summary ejectment, at least for 2 years, would definitely cover that remaining $600,000. Delegate Griffith.
In the original bill, how much of that fee was supposed to go towards the right to counsel?
The original fee was $30 was going to go to the right to counsel. Now it would be $33 that would go to the Access to Counsel Fund.
So my question is, the fact that we're not actually paying for counsel, why are we putting more money towards that program? Or not?
Because I think the idea is that it would go to, through MLSC, it would go to programs that provide that assistance to people who are, provide assistance through local housing organizations. It would provide assistance to them to at least give that access to counsel. You could conceive possibly of attorneys from different housing advocacy groups being at district court and providing those services.
And then my second question is, how can we prevent that fee being passed through to a tenant again, because, I mean, I know we debated this before, but I just feel like there's a conflict there. I don't know the law nearly as well as you, but we can't compel a private transaction, to not pass through a fee that they're incurring.
I don't think that there's anything that says we can't stop the fee from being passed through. And in fact, that's an issue. Both of the bills, Attorney General's bill and my bill initially did just that and stopped the fee from being passed through.
I apologize. Let me rephrase. But we can't stop the landlords from raising the rent to absorb it on the back end then.
Sure. I mean, and you could also argue that instead of taking the fee and charging the person the fee, they would simply charge the tenant a late fee anyway. So that's what would happen. That's what would happen in that case anyway.
I think.
All right. We'll go to Delegates Cardin, then Arakan.
Thank you, Mr. Chair. Very quickly, 2 questions. First question is, if we go to conference on this, is the bill dead?
If we go to conference on this, I don't know whether the bill would be dead or not. I've had indications that the bill might not be dead, but I'm waiting to get some confirmation that the bill that a conference is even possible at this point, to answer your question.
I've gotten numerous texts and emails from people saying they think that we should fight this, and I'm just trying to figure out because it seems to me as if, forget about right to counsel versus access to counsel. If you have money there, the Maryland Legal Services Court is going to figure out a way to use that money to give people counsel. So it would seem to me that we want to get that money in their hands. I just don't want the bill to die. So I'm looking for some thoughts on that before I place my vote. That's my point.
I understand that. Delegate Arakan.
Thanks, Mr. Chair. So in the Senate version, we've lost the provision that was going to allow for rental assistance. Is that
Correct. The rental assistance was removed by the Senate.
so? Now we're going to be giving all this money to lawyers and instead of to people to actually pay their rent, right? That's basically what's going to happen now.
There, as we've talked about on the floor, there's nearly $1.2 billion that's going to be coming into the state of Maryland over the next several years for rental assistance. And over again, we've heard about this issue and whether we needed to put money into these funds from this pool of money. Should we put that into rental assistance? And the argument that has come back is, and I know from the Public Justice Center, they've said till 2025. They think that they're good on rental assistance.
Okay, so and they've projected out who they think is going to end up needing it, because we're going to see, I think, over the next 18 months, people that don't think they need it now are going to need it. Is there projections involved?
The projections that we've gotten from the Public Justice Center say that even with the increases in the amount of in the demand for rental assistance, that even with that increase, that we would have enough money from the federal funds to be able to make do at least for some period of time.
Okay, thank you.
Delegate Conaway.
Thank you, Mr. Chairman. It's true that instead of the money going for the rental portion that we originally put in the bill, it might go to other resources. Is that true?
In the bill as was sent over from the Senate, and we've gone over the 5 minutes, and the bill that has come over from the Senate, the bill money goes in part to access to counsel, and then $17 of the 50 goes to MLSC to help fund the gap that they have in that organization.
Can I make a motion to send?
Well, hang on a second. I'm not going to hear a motion at this point because we have a couple other bills that we have to do. They're waiting for us on the floor, and this debate has gone too long. So I'm going to go to one more.
You're on mute, Sue. Sir.
Went on mute. I've got another bill from it's House Bill 1248. It's Delegate Washington's bill regarding data collection from police officers. It makes some technical changes in the bill. It's more or less as it left the House as I'm looking at it, but this is what would require the police departments to indicate settlements and put them on a public facing website. The motion for 1248 is to concur.
Move to concur.
Motion to concur is second. All in favor of the motion to concur on 1248, please raise your hands. Delegate Grammer votes yes. Conaway, Moon, Cardin, Anderson, William, Griffith, Lopez, Davis, Shetty, Fisher, Atterbury, Crutchfield, Bartlett, and Jones. Anyone opposed? Seeing no one opposed, we're moving to concur on 1248. On 1186, House Bill 1186 is legislation regarding the Attorney General's firearm and gun crime extension, the study extension. This study extension breaks it out another year. There was language added in the Senate.
Move to concur.
Second.
And the motion to concur in a second. The language from the Senate adds information regarding the number of times a red flag order was issued in a different county, so that it was part of the research as well. There's a motion to concur and a second. All in favor of the motion to concur, please raise your hands. Delegates Conaway, Moon, Anderson, Williams, Lopez, Davis, Shetty, Fisher, Atterbury, Crutchfield, Bartlett, Rachel Jones, all those, and Cardin, all those opposed. Delegates Cox, Griffith, Arakan, McComas, Cham, Malone, and Grammer. All right, we're going to concur in that. We are going to come back to House Bill 31. It is possible that we will come off the floor to do House Bill 31, and we'll be in contact with people shortly. So please go to the floor immediately.
Mr. Chair?
Back there, yes?
There are several of us that are on the annex, so we'll need time to scurry to wherever.
I understand. I do understand that. If you're in your offices and going to the floor,